David R. here. Today I'm going to talk to you about this book. Is There a Right to Remain Silent? Coercive Interrogation and the Fifth Amendment After 9/11 by Dershowitz. This book I found to be somewhat complicated at times. I think maybe overly complicated. Perhaps it could have been written maybe in layman's terms instead of having to go to a book like this, Black's Law Dictionary, in order to look up certain words. I don't know, but it's a book that you can get something out of, at least. I know I did, and if you're a law student, probably you'll get a lot more out of it. But Dershowitz obviously is a very smart guy. He's a lawyer, and he has represented people like Mike Tyson, Patty Hearst. He was even part of O.J. Simpson's Dream Team back in 1995. So he's a famous guy. He knows what he's talking about. All right, so since this book references the Fifth Amendment quite a bit, I'm going to read the shortened version of the amendment, but if you want a longer version, just go to something like this here, or search on the internet. Shortened version is, no person shall be compelled in any criminal case to be a witness against himself. So what this means is that you cannot be compelled under oath to be a witness against yourself at your own trial. The Fifth Amendment privilege against self-incrimination has undergone some different interpretations throughout the years. I'm only going to list 5, but the book has plenty more. The first one is the right to remain silent unless you choose to speak. The second one is the right not to be compelled to expose one's own guilt or self-incrimination. And again, you can look that up in Black's Law Dictionary on self-incrimination. The third one is the right not to be degraded. So basically, being compelled to incriminate yourself is degrading. The fourth one is the right not to be coerced by police into making an involuntary self-incriminating statement. This is like when police maybe beat a confession out of somebody. It's called the third degree. That's obviously against the law. The fifth one is the right to be advised of your Miranda rules. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, and if you can't afford one will be appointed to you. I think the most important few words of the Miranda rules are, whatever you say can and will be used against you. Remember that, because every word that you say can and will be used against you in a court of law. There's no doubt about that. All right, so the author goes on to say that we live in what's called a preventative state, and this has been ongoing since 9/11. What this means is that coercion is used in order to secure intelligence to prevent future crimes. Not crimes that have already occurred, but crimes that have not occurred. And really, this is unconstitutional. He also says that there's a broad versus a narrow view of the reading of the amendments. And the most famous one is the Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, if you are a liberal, you'll probably just focus on the well-regulated militia part. But if you are a conservative, you will focus on the right of the people to keep and bear arms. It just depends on which side you happen to agree with. Another one is liberals advocate a broad conception of sexual expression, but a narrow conception of corporate speech. And conservatives have a broad conception of corporate speech, but a narrow conception of sexual expression. Now, Alan Dershowitz says that liberals want to expand rights and conservatives want to contract rights. This book was published in 2008, so things have changed quite a bit since then. I think maybe the polls have shifted somewhat. All right. Well, okay. Now, the book lists several Supreme Court cases, but I'm only going to just briefly talk about one, which is Chavez versus Martinez. Officer Chavez had questioned Martinez while he was being treated for gunshot wounds, and he didn't read Martinez's Miranda rights to him. So what happened was it was ruled that the answers given by Martinez were compelled, coerced, and involuntary. So nothing Martinez had said was admissible in the criminal case. And you could look that up on the internet. You could go to this website, law.cornell.edu, and you can find all kinds of criminal cases there. He says that what coercion does, or the preventative state does, is creates a constitutional black hole, and this basically increases coercion by police into gaining information. The Constitution was designed to be reactive, not preventative. So what these officers and other government agencies are doing is unconstitutional. So the author says that if the courts are unwilling to impose meaningful constitutional limitations on government coercion, then we, the people, have to make a stand. And I agree. But before I go, I want to say that what coercion does, it just creates false confessions. Because the person being tortured is just going to say whatever they can to get out of that room or to stop being tortured. Anyway, I suggest you read this book sometime, if you like. It's not one of my favorites. I thought it was okay, but it did inspire me to buy this one, which I already showed you, Black's Law Dictionary. I like this little thing. 5th edition, from what I understand, is the best. All right, that's all I got. Talk to you later. Bye.